All right, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. And today we're going to be talking about why it's important to get your estate plan reviewed every so often due to legal changes. And I'll run through a couple of the big ones that have occurred over the last, 30 or so years, just to give you an idea of what I'm talking about, the kinds of changes I'm talking about. But before I get started, there's a couple of things I like to touch on first. So just to give you a little background on our firm. We're Hooper Law Office. We're located in Northeast Wisconsin. We do have 3 locations in one, our main office in Appleton, then in Oshkosh and Green Bay as well. But we are an estate planning and elder law firm. It's all we do. We don't do any other areas of law. We do estate planning and elder law and the subsets of those areas so that we can really focus on those and help people who have those particular needs. Currently we have 5 attorneys, so 5 full-time attorneys anyway. We also have a couple that are of counsel, so we have plenty of people who can help you out. You'll receive some forms at the end of this by email that let you fill out any feedback that you have. It also is a place for you to let us know if you would like us to reach out to you to set up time to talk. Our initial consultations are complimentary, so we don't charge anybody anything to come in and talk to us initially. We schedule them for 2 hours. They sometimes take a little less than that, sometimes take more than that. It depends on how in depth the conversation goes, or what somebody's particular needs are in that situation, and how long it takes to address it. But if you'd like us to do that, set up time to talk, that feedback form is a good place for you to do that. And then our topics next week are actually going to be on common caregiver mistakes. So same time next week. And during that, I'll address a lot of things that people do accidentally when they're trying to help a loved one prepare for care or taking care of them to help keep them out of a assisted living facility or skilled nursing facility that can end up causing problems. And then the week following, on August 3rd, we're going to be talking more about how to protect loved ones from themselves. When you're leaving them assets, what sorts of ways can we protect them from concerns that you may have over their responsibility or disabilities that they may have, or, from if somebody is getting sued or you have divorce concerns, right? Those sorts of things. And for those, you can sign up on estateplanninglive.com. So I'll touch on that again before I wrap things up. And again, this is a interactive webinar. So if you have any questions, you can submit them to the Q&A box and I'll actually see them come up. Actually, as I say that, let me pull that up. But I will see those pop up. And so we will answer your questions as they come in. But yeah, to get started, to actually dive into things, estate planning is sort of a long process over the lifetime that somebody has their plan in place. It's not one and done. You don't set these things in place and then never touch them again. I mean, most people are familiar with having to make amendments or changes based off of their own personal wishes changing, of course, making changes to a will or a trust to change the percentages on how someone's inheriting, or who the beneficiaries are, right? Most people are familiar with that. But too often people think that if they don't have those changes, they never have to have the estate plan looked at again because their wishes are in place. The problem is that unfortunately, or potentially fortunately, depending on the outcome of these changes, laws change, and they're really outside of the control of the general public and outside of my control as well. So having people come in for reviews every 3 to 5 years or so is really important. Because then we can talk to our clients about those changes and how they impact that person's estate plan. It's not the general public's, it's not their job to keep track of these changes, right? I don't expect the general public to know all the intricate laws that have passed or the actual outcome of these changes or how that's going to impact them. That's why it's important for people to come in. So if your estate plan that you have, if you have one in place, is older than 5 years, it's always a good idea to just have them reviewed and make sure that you have what you need in place. And if you don't, that you can have someone help you address those legal changes to, better get you a better result for your plan. And a lot of times that has to do with taxes, of course, tax implications of law changes or actual tax changes, but not always. Sometimes it has to do with other, rule changes that we have. So one of the handouts that you'll get from us is actually a list of changes over the last, actually, I think, did I say 30 years? It goes back more than 30 years, 36 years to be exact. It goes all the way back to 1986 on there of big legal changes that we've had. That people would want to get their plans reviewed because of those changes. Now, I would assume that most people anyway have had their plan either reviewed or drafted post 1986, but that's not always the case. I've seen some that are quite old. But to start with, one of the biggest changes that we deal with, when the plans are older than from 2003 to be exact, is dealing with HIPAA. So HIPAA is the law, if you're unfamiliar, or if you're maybe somewhat familiar but don't quite recall what it actually is the law that says healthcare professionals or organizations are not allowed to give out your protected healthcare information without prior authorization, so without you signing authorization for them to talk to third parties. And one of the most important documents we do in any estate plan is a healthcare power of attorney. If you have a healthcare power of attorney drafted prior to 2003, it's unlikely that it's going to have a HIPAA authorization as part of it, because the penalties for that law did not start until 2003. It was passed before that, but they gave a little bit of a grace period on it. So one of the first things I look at when I'm reviewing someone's estate plan is, one, do they even have that healthcare power of attorney? But two, if they do have a healthcare power of attorney, when was it drafted? How long ago was it drafted? I have even seen some drafted post 2003 that don't include HIPAA authorizations within the healthcare power of attorney. To give you an idea of why that's so important to have as part of the healthcare power of attorney, though, is if you have someone named to make healthcare decisions for you, but then they don't have authorization to get information from that medical professional, it puts them in a situation where they both can make the decision, but also don't have the information they need to make the decision. And that can put the family in a tough spot. I actually did review a healthcare power of attorney for someone. Thankfully, we were able to update it and fix it. But the issue they had run into in the past is that the doctor would not talk to them. The hospital would not talk to them because they did not have a HIPAA authorization separately on file, but also not one in that healthcare power of attorney itself. So having one embedded in the healthcare power of attorney is very important. Obviously, if these are the people you need to make decisions, you want them to have access to that information, of course. So one of the more dealing with the actual estate planning side of things, not the disability planning or incapacity planning, we look at things like estate taxes, right? So estate tax planning is something that changes, has historically anyway changed pretty regularly, probably more frequently than other tax changes. So back in 2008, for example, Wisconsin actually eliminated the separate estate tax for the state level that we used to have. So now Wisconsin has no estate tax. We still have the federal level estate tax, which changes based on acts of Congress and tax code changes, things like that. But which currently, if you're unaware, is currently at 12.06 million per person. So to have a taxable estate in Wisconsin at the federal level, you have to have more than 12.06 million dollars. So as a married couple, you have to have more than $24 million to have a taxable estate. Where for most of us, that's not an issue, right? I think it's less than 0.1% of the population when you actually do the numbers. So for most of us, we don't have that estate tax concern. One of the things that I see often, especially with older trusts, in particular older revocable trusts, there's a lot of planning in there that was set up to help deal with estate taxes, because the estate tax exemption, even at the federal level, used to be much lower than it is today. So you go back to the 90s and it was a little over 600,000, for example. Well, your difference between a $600,000 estate versus a $12 million estate is pretty big. So a lot more people in the middle class and upper middle class would have a taxable estate. So it was a much larger portion of the population than we have today. Well, if you don't have a taxable estate anymore, the planning that you have in place to deal with a taxable estate, it may just be completely unnecessary for you and maybe overly restrictive for what you would otherwise need in place. So I see a lot of what's called irrevocable life insurance trusts, or ILITs, that people still have that, they either are nowhere near having a taxable estate at the current level, or they haven't kept up and they're just not working for them anymore. So those are the types of things where, especially with estate taxes, those change on a relatively frequent basis. And if you're familiar with how legal changes works, relatively frequently means, more than every 20 years or so. But estate tax changes occur relatively frequently, so frequently, in fact, that our last estate tax change was back in 2017, so not that long ago. That's where it got set at the current level, indexed for inflation. Now, one really big change coming up with those estate taxes is actually within the next couple of years here. So starting at the beginning of 2026, that 12.06 million is actually going to decrease. They did not have enough support when they passed that increase to keep it permanent. So at the end of 2025, beginning of 2026, that will actually go back down to what it was previously, but indexed for inflation. So prior to that law change, it was $5 million per person with inflation. Now they're estimating that it'll be around $7 million per person. Of course, that does completely depend on how they index it for inflation, right? But roughly around $7 million a person. So there may be those of you out there who are going to have more of a concern or closer to a taxable state, and that may be something you want to address than you do currently. And that's a really good reason to have things reviewed. So estate taxes still probably won't be a concern for the vast majority of the population, because it's still a married couple would have to have 14 million at that point. But it's more of a concern than it is now. So just to give you an idea of how close in time that changes and when you might want that plan reviewed. I'll stop talking about estate taxes, because I know that's not generally a concern for most of you these days, but it is an important one to touch on nonetheless. One of the biggest changes to rules that came into play regarding trusts, for example, is in 2014, we have had an entirely new trust code put into place, right? So we had old statutes that dealt with trusts still prior to that change, but now the statutes are numbered differently in some places, or are under a new section of the statutes. And it's really important to have those as up to date as possible in your trust. You can always amend the trust to incorporate those new provisions. The reason it's important is not because it invalidates old versions of trusts. If the statute that your trust is referring to give it authority to do something is the old one, that doesn't invalidate that section. It just makes it more difficult potentially down the road when it comes to time to administer the trust after you've passed away, to actually figure out what that's referring to. For example, I started practice after that change. So I'm more familiar with, I can look at a statute now and say, I know what section that's referring to, what it's generally talking about. But if it was something from 40 years ago, I would likely have to look up what the old version meant. And that's an attorney who is an estate planning attorney doing that, right? Imagine an individual having to try to figure this out and not realizing that we're talking about an old version of the trust or an old version of the trust code. But outside of those changes, the new trust code gave us more expansive authorities that we can add into trust that we didn't otherwise have. It made things clearer in some instances, gave more clear, statutory authority for things that, your trustees can do, or that, things like trust protectors, where somebody can help amend the tax language of the trust after you've passed away. So it's more flexible now than it used to be. And that's a really good reason to get it updated, because if you don't have those authorities in there, you never know what types of amendments are going to be needed to be made for tax purposes, for legal changes. And frequently have to add new tax language in, even after someone's passed away, because it had been long enough that they hadn't had the new tax language put in, or they don't have planning to deal with it, right? So, and by tax changes there, I'm more talking about like IRAs, for example, or general income tax, capital gains tax, than I am talking about estate tax. That sort of planning you generally have to look at doing in advance. So, the Wisconsin Trust Code changed in 2014. That's when it was completely revamping everything, and it just gave a lot more authority. So it's a really good idea if your trust is older than 2014 to have it looked at, see what changes can be made, see if it's still in place for you. I mean, at 2014, you're 8 years older now than a current updated trust. So it's really a good idea anyway to have it looked at, but particularly because of all the new things that we can do. But when it comes to updating trust on a more regular basis, other documents are important too. I mentioned trust a lot because that's one of the bigger changes we've had. But when we're talking about things like powers of attorney, those changes come up a little more frequently. And with financial powers of attorney, so not healthcare, we've had some changes in the law, some additional things we can include. With the financial power of attorney, for example, one of the biggest changes is dealing with digital property. Back in 2016, Wisconsin adopted a Digital Property Act, which says, okay, now powers of attorney can deal with these things: online accounts, passwords, online only bank accounts where it's cash online. And in theory, this could be really important for those of you who may have online digital assets like cryptocurrency, right? And I know maybe that's not a good thing to bring up right now with how the crypto market is going, but that being said, it's still property that you have. And crypto, of course, has other considerations that you have to take into account because of the private nature of it in a lot of ways and the way it's held. But in general, if you have an online account dealing with those types of assets, you want your power of attorney for finances to be able to access those, because if they don't have access to online digital property, it's not authorized in your power of attorney document, that can be difficult for them to know where things are, how to deal with things, or make quick decisions on it. So one of the biggest changes we have in the financial power of attorney from a legal standpoint over the last couple of years, 6 years, I guess, to be exact, would be including the access to digital accounts, digital property. Passwords technically are part of that as well. They are considered your property to an extent. But outside of the legal updates for powers of attorney for finance, one of the things that internally we're constantly working on, for example, is making sure that if we run into issues with clients or other people have run into issues with their clients, that something was needed to be expanded upon authority-wise on a power of attorney, or it's a new issue that someone's encountered that we want that authority included in the financial power of attorney. We are constantly looking for ways to update and add language to that so that our clients have as much authority as they need their loved ones to have to step in for them and make decisions. One of the biggest authorities that people don't often have, or it's more of a collection of authorities rather, in their financial power of attorneys, is the ability to deal with things like prospective long-term care planning or emergency long-term care planning. And it's not like it would just say that, of course, but there's issues with people having limits on gifting or not being able to set up irrevocable trusts, or having no mention of dealing with things like applying for Medicaid benefits, right? Those are as a couple examples rather, those are examples of things that you would definitely want somebody to have in their financial power of attorney, so that if they became incapacitated, their loved ones could still deal with those sorts of planning options. I review powers of attorney pretty regularly, either the statutory versions or ones that people have from a long time ago, where they're very, very limited in what somebody can do. And, there's some argument that, well, if they're limited, that means that you're not letting someone have access to those things. Those powers, you're limiting what they can do. But if you trust someone to step in and make decisions for you, it's really important to give them as much authority as they could possibly need, because we just can't predict what types of authority somebody's actually going to need when the time comes. And if that person who originally granted the power of attorney, powers to that person, if they've lost capacity and can't sign an updated power of attorney, we may not be able to have those authorities granted. And even through guardianship, those authorities might not be granted. And that's just because powers of attorney for finance are always going to be able to grant more specific authorities, more expansive authorities than a guardianship court would be likely willing to grant. So looking at powers of attorney, very important. especially for if there's potential concern for long-term care needs. The gifting issues we run into with that is they're often limited to the annual gift tax exclusion. So to give you an idea of what that actually is, it's currently $16,000 per person per year that you can give without having to file a gift tax return. The problem with limiting your gifting to that amount is if you do need to plan for long-term care expenses, you're not able to protect quite as much because your agent is limited in how much they can actually gift at any given time or move to protect things. So why that limitation is often in there is it goes all the way back to the estate tax issue, where people were trying to not have their agents cause an estate tax issue for them. Your gift tax exclusion just means if you gift over that exemption amount, you have to file a gift tax return with the IRS, which says, okay, I've used up some of my end of life estate tax exemption. So for most of us, again, it goes back to, we are not going to have an estate tax issue, even if we go over that amount for most people, because you would still have to give more than 12.06 million over that annual gift tax exclusion during your lifetime in order to have a gift tax owed. So we're not really concerned about that for most people anymore. We're more concerned about dealing with flexibility around long-term care planning. So I point that out just because it is a very common, restriction I see on those documents. One I reviewed actually had the specific at the time gift tax exemption mentioned. Most of the times they'll at least say, oh, it's whatever the annual gift tax exclusion is that given year, so that at least it goes up with inflation like it's supposed to. But one was limited to $10,000, which it hasn't been for many, many years. So that was even more restrictive and unnecessarily so. One of the more recent changes that we've dealt with a lot, especially with trusts, but in general, is a change, a new law that was passed at the end of 2019, came into effect at the beginning of 2020. Some of you may be aware of it already if you've talked with your financial planners about, or your CPAs that you work with about IRAs. It's called the Secure Act. Congress loves their acronyms. It's Setting Every Community Up for Retirement Act, I believe is what it stands for. But it changed a couple of really important things for both during the lifetime of the owner of that IRA and also the length of time that somebody is going to have to pay the tax and take those accounts distributions out after they've inherited them. So the big change for the account owner, the original owner, is that the required minimum distribution age went up from 70 and a half to 72. They're actually talking about upping that even further, and it has passed the House, I believe, but I haven't heard anything about it in the Senate lately. So we'll have to see where that goes. But they're talking about upping it even further, incrementally up to 75. That just hasn't passed yet officially. So 72 is now the new required minimum distribution age. It also means that that change meant that people who are working after 70 and a half can still continue to contribute to an IRA as long as they're working. It used to be at 70 and a half, as they started the distributions, they couldn't contribute anymore. And now that people are working longer, people are retiring later, they wanted people to have a longer period of time to continue to add to that, especially because of those statistics out there that people are not, most people have not saved a lot for retirement when you look at the overall population. But aside from what it's changed for you as the individual owner, it also changed how long the beneficiaries have in most circumstances to take out those accounts. It used to be when you left your IRAs to your children that they would have their life expectancy to draw it down. They would have to start right away. They'd have to start taking required minimum distributions the year they inherited, but they would have to stretch it out over, potentially decades if they were a certain age. I mean, as someone in their 30s would have roughly 40 years potentially to draw that down under the old rules. But now the big change was that, barring a few minor exceptions for beneficiaries, they now have no more than 10 years to actually take out that account. Congress wanted people to pay taxes on these things sooner. So if it's a pre-tax IRA, the big change was making sure that, traditional IRA, 401k, any of those types of accounts that are qualified, they wanted the beneficiaries to pay taxes and not hold off paying these taxes for, 40 years or so. So the side implication of that, of course, is that there's now more tax planning that needs to be done, more things that your CPAs, your financial advisors, your estate planning attorneys can help you address to prospectively lessen the tax burden on the kids. And I certainly have plenty of clients who have said, well, that's their problem, and that's, to each their own. But if you do want to address it, you have some options that you can talk about. So with our trusts in particular dealing with that, we talk a lot about asset protection for the kids and protecting what they're inheriting. Well, under the prior retirement account rules, we would generally say any income that was, the distributions from those accounts would be given directly to the beneficiary, even if they inherited a trust fund. And that was to give them a lifetime stretch, make sure it saw through to them. Well, now that it's, for most people, no more than 10 years, we don't necessarily want to force everything out to them, because there's risks that they will have to potentially, lose the asset protection much quicker. So we want to give them a choice, and that's the big change we've made. But there are some exceptions to that 10-year rule. Just to give you an idea, spouses, for example, they still get a lifetime stretcher to roll it over into their own name. So that hasn't changed. It's not like spouses suddenly have only 10 years to take it out. But a couple other exceptions are minor children of the account holder. So you can't say I'm leaving it to like my minor grandchildren. It has to be your children. And they have to be minors. They get a lifetime expectancy stretch until they're age 18, and then they have 10 years to take it out. So, a 10-year-old would actually have closer to 18 years to take it out. A few other exceptions are somebody who is, disabled under the IRS code, the meaning of the IRS code. They can get a life expectancy stretch, and then somebody who's not more than 10 years younger than the original account holder. So that is actually one I've had come up as a discussion more frequently, because sometimes people are leaving their IRAs, actually, if they don't have kids, leaving it to their siblings who might be pretty close in age. And that, they're not more than 10 years younger in a lot of cases. So their siblings actually get a life expectancy stretch. So that's a big change for you. And that's not just the legal change, but also a financial planning change that you want to address as well. But there are changes within legal documents that can help you deal with that more efficiently, help, better accomplish your goals of maybe protecting those assets for the kids and giving them a little more flexibility around the tax planning options than they would currently have now in a lot of older versions of trusts. So I am running close to time here, but I just want to give you a couple, quick reminders again that you will receive some materials from us at the end of this, primarily the initial consult. If you want us to reach out to you to set up a time to talk, again, those are complimentary. We schedule them for about 2 hours. And then you'll also receive the handout I was talking about, where it goes through all the different legal changes, or the significant ones that we picked out over the last 30 or so years, or in this case, 36 years, I believe is what I said. So, that's a helpful tool, at least to give you a primer on, these things have changed, and they're not insignificant changes. Otherwise, if you are interested in our next week's topic of common caregiver mistakes for someone, caring for a loved one, or the following week are protecting loved ones from themselves, please feel free to sign up for that on estateplanninglive.com. Otherwise, I will let you guys go and enjoy the rest of your day, but I hope to see you guys next week.